Okay, we have one case on the docket, and counsel, if you're ready, I think we are.
Thank you very much. May it please the Court, Elizabeth Russo on behalf of the appellants Thomas Linzy and Erosion Stoppers, Inc. I'd like to reserve 3 minutes, if I may, for a rebuttal. We're seeking reversal of a new trial order in this appeal, and the order was based on 2 remarks that were made by defense counsel in closing, in which he was saying that the defendant should not be asked to pay for a lifetime of medical expenses for a back problem that the plaintiff already had before the accident and knew that he already had before the accident. Respectfully, we think that the trial court wrongly characterized the remarks as running afoul of the case law that says that you should not contrast the wealth and poverty of the parties.
Let me ask you a question, Ms. Russo. Okay, thank you. You know, I read this, and my first thought is, what choice did the judge have? The judge had entered an order on the initial motion in limine before the trial. He sustained objections. There was another motion in limine filed before the closing argument. He admonished, he warned, he entered orders. What other choice did the judge have?
Well, I think that the motion in limine that was filed originally was just a sort of a generic long list, and it was talking about the contrasting, yes, but contrasting wealth and poverty. And I really think that that's the key to this case, is that the remarks came to be characterized as made.
What I'm asking you, I need you to really answer me directly. What choice did the judge have? The judge had to try to control his courtroom and try to control what was going on in court. And he had told counsel over and over, don't go there. I'm not sure what choice the judge had.
Well, the choice was, what was before him was to make sure that there was nothing interjected in front of the jury that was improper. But the remarks that were made, and it's 2 remarks in closing, there was no objections before that to anything. It's 2 remarks in closing that get made, and then there's an objection. But the motions in limine, and it was all directed towards, you're not supposed to contrast the wealth and poverty of the parties. And that's not what defense counsel was doing here. So I think that probably the judge hears the word pay. This man or this defendant shouldn't be required to pay for a lifetime of medical expenses.
But it seems like it was more than just contrasting wealth and poverty. It seems as if the comments were directed toward implying that any judgment would be paid individually by Mr. Cruz, and that wasn't the case.
Well, I mean, counsel talked about it, and that wasn't what he was intending. He was faced with a situation where in this case the plaintiff, he was deposed, and he gave sworn answers to interrogatories after filing this suit. And in both he said, I had no pre-existing injuries, I had no back problems of any kind. And then the further discovery was done and all his medical records were obtained. This is not even a case where it's one doctor, the defense doctor says yes, the plaintiff's doctor says no. This is the plaintiff denying that he has any problems with his back. And then in discovery, it's determined from his own medical records that he has a congenital spinal stenosis that has caused him problems his whole life. Counsel's point in making these arguments, I mean, it was, I think, surprising in any case to find that big of a lie, but then to have the plaintiff come to trial and anyway try to blame it on the defendant. The real point that counsel was reacting to was whether the defendant's General Motors or whether it's whether it's Tom Linzy, how can this plaintiff be here asking you, the jury, to make anyone pay for his back condition?
But that's not what he said, though. What he said was, you should not make Mr. Cruz pay. I mean, Mr. Cruz isn't even a defendant in this lawsuit. I mean, you would be a little bit closer if you said Mr. Cruz's company. But here it seemed to me that what he was doing was a classic case of playing to the sympathies of the jury about, you know, poor Mr. Cruz, the local businessman, being held responsible, and it wasn't held responsible, paying for this plaintiff's fake injuries. I mean, how is that not unduly prejudicial?
Well, because he shouldn't have said Mr. Cruz. I think it's because it's the only person sitting in the courtroom and because the defendant had so little to do with anything. Nobody was ever called for the defendant, not Mr. Cruz, not his company, not the driver. They never had anything to do with it. It was all about, were this plaintiff's injuries caused by this accident? And so that's where he gets into it when he's talking about it. He says, he's talking about he had just gotten 2 diagnoses or 2 recommendations from people before the accident that he go for that he get pain management. And he's upset that the plaintiff comes into trial and says that, oh, he forgot about all that. He didn't remember any of these treatments and these recommendations. And he says he forgets Ed Fraser Hospital, where a person treating him not only wrote him a prescription for a Class II narcotic, he said, you have to see your doctor for a pain management referral. This man over here, Mr. Cruz.
It's almost like you're asking us what we would do had either one of us been the trial judge, rather than asking us to recognize the judge's discretion in granting the new trial. Even the cases that you cite talk about the broad discretion that a trial judge has, because the trial judge is there and has seen the trial develop in the context of what's going on.
Well, I recognize that this is a matter that's discretionary with the trial judge.
And if the trial judge had not granted a new trial, you would be here making these arguments, and then, you might be able, with the same argument, to support a conclusion that it was harmless error. But the judge had granted it, and it's abuse of discretion. So how do we get there?
Well, okay, the cases that the judge is relying on and cited in his order are the cases that talk about don't contrast the wealth and poverty of the parties. All right, Battlemento versus Dove is one of the ones that he cites in his order and that the parties talk about. You'll see that in each case what's happening is that the wealth and poverty of the parties is being contrasted. If you have two parties that are rich as Croesus or 2 who are poor as Job, it's not going to make any difference to the jury one way or the other. It's when you're contrasting. In Battlemento, for example, it's a family that buys an Italian restaurant in Orlando from another family that has many other restaurants, and the buying family does badly, and they talk about that they put their life savings in and they lost everything, and the other family is flourishing. That was the problem, was that it was contrasting. Because
the motion in limine doesn't speak to just the relative wealth and poverty of the parties. It speaks to the issue of the burden on the defendant having to pay. And this is directly saying this burden goes on Mr. Cruz. Mr. Cruz is being asked to pay for a lifetime of pain management. Now it's all you, Mr. Cruz. You pay for everything.
I'm saying that the case law that this is all based on and that the judge's new trial order was based on is
there are nuances of that.
Is making the contrast.
I mean, to imply that somebody's the little guy really is a part of that kind of comparison.
Well, but there isn't.
It's certainly asking for the jury's sympathy.
Here's there's 2 remarks that are, this man over here, Mr. Cruz, is being asked to pay for a lifetime of pain management that he received 2 separate referrals for within 2 weeks of this accident. The accent there is not on poor Mr. Cruz. They never heard anything about how much money Mr. Cruz has or doesn't have.
Well, even if Mr. Cruz is fabulously wealthy, that's just false.
What?
Mr. Cruz wasn't being asked to pay for anything.
Well, I will grant that the saying Mr. Cruz was not on the money. He was talking about the defense.
Mr. Cruz's company was not being asked to pay for anything. There was insurance. Of course, they couldn't say, no, there's insurance.
But my point is that whether it was Mr. Cruz or defense counsel would have been just as happy saying he's asking an insurance company to pay for the rest, or Mr. Cruz or General Motors. The point was nobody should be being asked to pay for a pre-existing injury, and that's the point that he was trying to make.
And the point that he's making, I guess, I don't have a problem with, nor probably would the judge have had a problem with below. I mean, I think it's a perfectly fair argument to say this man had a pre-existing injury and we should not be held responsible for it. But when you start pulling in Mr. Cruz's company having to pay for it, I think Judge Roberts' point is the key one. That's what the motion in limine went to. We're not going to talk about who has to write the check, because we know who has to write the check, and it's not Mr. Cruz and his company.
Well, respectfully, the case law that the motion in limine cited and was based on, and it was, is this line, the Battlemento line of cases. And they're always going, it's not just a question of who has to pay, because
Well,
nobody
then,
ever gets
even
into
then,
insurance.
The judge in his discussions went further than his initial order on the motion in limine did. And during the discussion, the judge made perfectly clear that defense counsel was not to imply that Mr. Cruz was going to be individually responsible.
That was when the objection was made during the closing, and he said, and there was a motion for mistrial, that's the first time it was discussed, and it was never mentioned again. And he said, if you go on like this, it's going to mess up the whole week, mess up the trial, and we'll have to have a new trial. But he had not that far considered it enough to grant a new trial or to declare a mistrial. He said, if you do it again, and it wasn't done again. But I do think that, I'm sorry.
Let me ask you, I'm sorry to interrupt, but what is the best case you've got for us where a appellate court reversed the grant of a new trial based upon improper argument?
Oh, I'm sorry. I've been so focused on the wealth versus poverty cases. I know it's done from time to time, but this may help. In Battlemento, the court said in a footnote that many courts had found this error harmless, where the record otherwise contained enough properly admitted evidence from which the jury could find out the relative economic status of the parties. Now here, there wasn't supposed to be any evidence about the wealth of either of the parties, and there was never anything about my guy, rich, poor, big company, huge conglomerate or otherwise. And the plaintiff was also not supposed to put in anything about his economic status or his earnings, lost earnings, because he wasn't making a lost earnings claim, but managed to get it in nonetheless through a doctor, through blurting it out himself, and through something that his counsel asked one of the other doctors. So what the jury did know was that the plaintiff could no longer work. So if you're let's say that they got some notion that Mr. Cruz or his company was not that wealthy. Of the two, at least it was a company, the plaintiff was the poorer. And what you worry about with this whole interjecting wealth or poverty or who's going to pay is that going to be why the jury's deciding because this one has the better ability than the other one has? And here, if that's the consideration, the plaintiff had the better of it.
I always understood the reason we don't let the jury know about insurance is because they would say, oh, well, if an insurance company is out there going to pay, we'll stick it on them. Whereas if they don't know the insurance is out there, they will decide the case based upon who's legally responsible. And so I guess I'm struggling to understand. I mean, it was your client who didn't want that information about the insurance company being ultimately on the hook in the record, wasn't it?
Well, I think it's impermissible, period.
But your client filed the motion in limine on that issue.
Much, yes.
But at the end of the day, the record and the trial judge seemed to believe the argument went down that road in saying, actually, it's Mr. Cruz who is going to be on the hook for this, and at that point there was nothing that could be done. Wasn't that the point in the Hollenbach case?
No, I think Hollenbach is the perfect emphasizing the fact that it's contrasting that you're doing. In the very sentence that was said in Hollenbach, it was, I represent Hollenbach, who's a merchant marine, not some fancy company, not some big conglomerate. He's contrasting and saying, look, this is a poor man, not a big rich company. And of course, the case goes on that information couldn't be rebutted because insurance couldn't be brought out. No, but the point is that he's saying this is why you should make your decision, whereas in this case, if you're going to be contrasting, all right, there's no insurance there, but if you're contrasting, the plaintiff is the one who has been, if that's what's motivating the jury, the plaintiff is the one who's gotten in more evidence about how poor he is. I see that my time is running out, so I guess I'll reserve the rest for rebuttal.
First of all, I'd like to say this is just a beautiful courthouse. And it's my first appearance before the First District, and I'm quite impressed. My name is Charles Trincali. Your Honor, our position is very simple. It deals with the exercise of discretion of the court, and I submit that, I mean, if you look at the linear look at the exercise of discretion in a linear fashion. I mean, did he stay within the bounds of discretion, or did he abuse it? If you look,
well, there were several times where he used the words pay or buy in the opening statement, but that was unobjected to. Can we look at that at all, or do we have to just go to the statements at closing argument, and are we limited to just that?
I don't believe that you're limited only to the statements in closing. Well, ultimately, the effect of the statements will make or break the judge's ruling, but I believe what was said in opening gives context. Of course, what the plaintiff was asking. He was asking for $87,000 in past medical expenses and future medical expenses of $600-something thousand for 38 future years. You can't take the statements in closing argument in a vacuum, because when he's saying this man is going to have to pay, they're going to, I mean, pay what? Pay the money. And in fact, the opening served as the introduction, which gives meaning to his statements. And, Your Honor, the way I understand.
Yeah, but somebody was going to have to pay. I mean, insurance is not magic. It's not free. I mean, someone pays.
Yeah, but he, in this statement, there's, in the two statements, and they were rapid fire, it made no mistake but that Mr. Cruz was going to pay and no one else, because after he said Mr. Cruz is being asked to pay for a lifetime of pain management, he then says his company unfortunately gets in an accident with Mr. Rayburn, and now it's all you pay for everything. So what he it's not that he implied Mr. Cruz would have to pay. He juxtaposed Mr. Cruz versus the company and said it wasn't this non-party's fault, but he's going to have to pay everything. And if you believe all the testimony, unfortunately, this poor little man is going to have to pay, hundreds of thousands.
So he didn't just imply it; he flat out said it, that Mr. Cruz was going to have to pay.
Oh, yeah, yeah. There can be no other rational reading of those.
But that was objected to, and there was no discussion of any kind of curative instruction from the judge.
Well, yeah, what the plaintiff's counsel did was he asked to take it under advisement. The judge did acknowledge it was, sustain the objection, and advises counsel not to do it anymore. But you ask, what could the judge do? What could the counsel do? This is the end. He can't come back and rebut and say, hey, wait a minute, ladies and gentlemen, they have insurance coverage. I mean,
well, counsel, couldn't he have said, Judge, I want a ruling on my motion for mistrial. This is completely prejudicial. I can't come back and rebut this. I've got no hope at this point. I mean, at this point, all the evidence has come in that the client has completely lied about his insurance coverage. He knew what the outcome was going to be. Wasn't counsel's only hope at that point to get a mistrial and come back and, try again. I mean, and so at that point, because he asked the judge to take it under advisement, doesn't that imply that in context of 30 pages of closing argument, these two isolated statements were really not that big of a deal?
No, Your Honor, I submit because there's no curative instruction that could have neutralized the harm. The judge could not say anything other than disregard the argument.
Yeah, but judges say that all the time when improper evidence comes in. There's always disregard that last statement, and the trial goes on.
But it's an appeal to the jury. I don't believe that a curative instruction could have had the effect of undoing the wrong.
Right. I guess that's my counsel. I guess that's my point, though. I agree with you that curative instruction, other than disregard the argument, may not have helped. But I guess if it was that prejudicial, if it truly was an appeal to the sympathies of the jury, isn't the remedy a grant of the mistrial at that moment? But that's not what you sought. Your client sought to take it under advisement. So why wasn't the fact that a mistrial wasn't granted, why isn't that significant in evaluating how non-prejudicial or prejudicial this statement was?
Your Honor, to give the judge time to review the matter, not in the heat of battle, if you will, which he did, if that were the case, then there'd be no reason for a motion for new trial. I actually believe that the court's judgment was even more verifiable, more credible in that he gave it thought. It wasn't a snap of the decision, a thought. Was a mistrial motion, does that preclude the court exercising discretion in a motion for new trial for the same matter? I believe had the judge been forced to do it, I believe he would have declared a mistrial. He wanted to see if, because he wanted time. He chose to take it under advisement.
Well, and a trial judge really can't be forced to enter an order on a motion for mistrial at that moment. I mean, the judge gets to decide when to enter that order or when to make that ruling.
Yeah. Your Honor, it didn't happen here, but to say that a failure to request a specific curative instruction would undo the harm and cause the judge's discretion, exercise of discretion in a motion for new trial as abusive, I just don't believe it logically follows. Perhaps it would have been cleaner, but what we are faced with here is the exercise of discretion in the motion for new trial. And, Your Honor, I would submit that at the time this was said, there was no offer. It's worse than the Hollenbach case, because in the Hollenbach case, as I read the court's decision, because it happened in voir dire, the court went over, well, this couldn't have even been responded to in the trial because of prohibitions against admitting or commenting on insurance coverage. In this is the last thing the jury heard, and it's significantly powerful, and it's incapable, absolutely incapable of rebuttal.
In evaluating whether the trial judge abused his discretion, in your view, can we look at the weight of the evidence, the obviousness of the verdict in this case?
I believe you can look at the weight of the evidence. That's a factor. But, Your Honor, when you also look at the fact that only one witness testifies for the defendant, and I submit there was an issue on my client's credibility that's been pounded on by the defendant, I would submit to you that even if it were 50-50, it's only a preponderance of the evidence standard, and then this comes out. Your Honor, if the court were to find that these statements were proper and that the judge actually abused his discretion in granting the new trial, the rule in Hollenbach is meaningless. It really is. it will be the bar for defense counsel in closing arguments. The last thing they will say to a jury is that, and then argue, well, overall it didn't matter. I submit to you that we're not saying that the case was strong for the defendant. We're saying it was a triable case until that said. That was the door shutting comment. It was.
So in your view, up until that point, the 30 pages that proceeded in the argument that, as you say, hammered on your client's credibility, but up until those words were uttered, this case could have gone either way.
I believe it could have. I believe it could have gone either way. But even if this is not a case of harmless error and therefore an abuse of the court's discretion, this is a case where the rule of law was, and I'm not suggesting bad faith, but was ignored, disregarded, and a judge's exercise of discretion is to be faulted for what I would submit is just as clear-cut a violation of the rule as ever. And again, at the time it's made, I submit to you there is no curative instruction that could have cured the harm
Let me ask you this. If those statements at closing argument were what caused this case to go the other way in your view, what about all the statements in opening argument that you bring our attention to that weren't objective? I mean, those, in essence, to me, were almost the same thing being said in opening argument, but in your view, those didn't affect the case. It was not until closing in these two comments that the case went the other way.
I misspoke then, because I would say you do take it in context. You look at them, but the bottom line is what was said in closing argument. You do look at them for context. And the way I read this, I read the motion and the hearing of the hearing on the motion for new trial, Your Honor. What plaintiff's counsel explained and to the court, and this is right in the record, that Your Honor, he made these statements in opening. He made these comments in opening statement. I was appalled. I was shocked because I had filed a motion in Lemonade to prohibit that. That is why he said, and Judge, that is why I typed up and filed my fourth motion in Lemonade. For heaven's sakes, we'll live with this. It's not like he liked it. He just made a strategy decision not to interfere, not to oppose during opening statement. And then he says,
so he made a strategy decision to allow what you would consider highly prejudicial, inappropriate comments to come in an opening statement, waste a week of the court's time.
Your Honor, no.
And then object? Is that what you're telling us?
There's a difference between what is said in opening statement, and then the evidence doesn't bear it out, and what is said in closing statement. There are, it's apples and oranges. What's said in closing argument to which there is no rebuttal. I often allow statements in a counsel to, as a strategy decision, make statements in opening statement that I know that they can't present evidence to establish. So no, that it's opening statements set the tone and was the cause for, once again, Your Honor, please protect the rule of law, which was, again, in fact, right before the closing.
So why wasn't all this invited error? If what you're telling us is counsel made a strategic decision in opening argument to set the stage for this, then, you know, leads down the way, and at the close of trial, when you see how the case developed, you think, we're going to get a defense verdict here. Now I'm going to object. And Judge, why didn't you bring this on yourself?
Absolutely not. Then why would he have filed the motion in the fourth motion in Lemonade?
So there was a motion in Lemonade before the trial.
Yes.
There was a motion in Lemonade mid-trial.
Yes.
There was a further objection.
And then there was, prior to closing arguments, immediately prior to closing arguments, the court had heard the fourth motion in limine, and Mr. Flaherty said, I want to avoid this happening again. He made reference in opening. He didn't waive it. He pointed the judge directly to it. Judge, please don't let this happen again. And then Mr. Kassane absolutely assures the judge, of course I will honor the law. And then he says that. And that's not, to suggest invited error, no, that's not invited error. The counsel did act properly, Your Honor. And the court on these, if these words do not establish a basis for a grant of a motion for new trial, then I would submit the rule of law in Hollenbach as meaningless.
Thank you.
This is coming down to...
Okay, even if we come to the conclusion that we would have done differently than the trial judge, we have to find that no reasonable trial judge would have granted a new trial.
Well,
so would you speak to that and tell us?
Yes, Your Honor.
Okay.
At the moment, when it's directed to the trial judge himself and to his discretion, there's been 30 pages of argument. There's another 10 or 15 that goes on after. At the moment that it's directed to him, what he says is, I'll take it under advisement at this time. If you do it again, we won't. It will mess up the whole week. I mean, just stick to the issues, the facts of the case. So he's just heard it. He's been there for the whole trial. And at that time, he's decided it's not enough. If you do it again, you get into this again.
He's admonishing counsel. If he takes it under advisement, he can still enter it later on. It may come out to be a different kind of verdict, and he wouldn't have to enter that. To me, what he's doing is admonishing counsel and saying, don't do it again.
But he goes on to say, if you do it again, it'll mess up the whole week. Meaning, to me, that's at that moment when he's reacting to it with his discretion at the trial itself. It's not that bad. The whole week is not messed up yet. So don't do it again. Let's stick to the.
No, I don't read that like that at all.
Well, and I think that because of the remark that he was reacting to, and I again submit that the law and the danger you're trying to prevent is that the jury select one party over the other because of their wealth or their poverty, and the plaintiff had already established that he was the poorer of the two. So that's not what this jury verdict was based on. I don't think that there should be a new trial in this case for this plaintiff. Thank you.
Thank you, Ms. Russo.